Yeah, it's dark.
So it's almost done. It's
All
been-
right, call to order the October 21st, 2025 meeting of the Alcohol and Tobacco Commission.
Closer.
I will note that we have a quorum. And next item on the agenda, the disposition of minutes from the October 21st, 2025 meeting.
Madam Chair, members of the committee, we have the minutes from the meeting of October 21st, 2025 of the Indiana Alcohol Tobacco Commission. I have extensively reviewed those and they are accurate. I move acceptance of the minutes as proposed.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item on the agenda, the prosecutor's recommendations.
Madam Chair, members of the committee, we have a report from the prosecutor indicating this last term, there were 45 violations. And they resulted in fines of $33,200. There are 5 worthy of note. The first comes from Fort Wayne at the Double Down Sports Bar. There was an alleged shooting there and stabbing at the business. Officers investigated, looked at the footage, determined that there was a public nuisance and failure to maintain high and fine reputation. The parties have agreed to a $1,000 civil penalty and a 3-day suspension of the alcohol permit. Second, it comes from South Bend at the Last Stop Liquor. Officers there were doing enforcement and observed a 17 and 19-year-old enter and exit the store and purchased alcohol while inside. This was the 4th sale of minor sale. And in the last 5 years, parties have agreed to a $2,000 civil penalty, $7 suspension of the alcohol, 7-day extension of the alcohol. The third comes from Indianapolis King Liquors. Conducted an investigation there and 2 underage females entered the store and purchased alcohol without being asked to identify themselves. While writing the violations, other underage customers came in to purchase alcohol. This is the 3rd violation for sale to minors. Parties have agreed to a $2,000 civil penalty and a 3-day suspension of the alcohol permit. The 4th comes from Warsaw, Indiana, at the local Citgo there. A juvenile had been hospitalized following consumption of the THC product from the business. The officers investigated, and while there, they were identified and seized smokable hemp products, and criminal charges were filed. An administrative violation was filed for nuisance. Parties have agreed to a $1,000 civil penalty and 7-day suspension of the tobacco certificate. The 5th and last one comes from Terre Haute at the LIT dispensary and vape. Officers were doing an investigation there and purchased synthetic urine for the purpose of passing a drug test. Violation was written for that. They have a prior violation for sale of nitrous oxide. Parties have agreed to a $1,000 civil penalty and 3-day suspension of the tobacco certificate. I move acceptance of the prosecutor's report.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Hearing judge recommendations, there are 2 today. The first is for RR 4506264, Bernice Carter. I'll open that for discussion.
Madam Chair, fellow members of the commission, I heard this matter some time ago. And I've since tendered, obviously, my proposed findings of fact and conclusions of law. Appearing at the hearing, people included, in addition to the IATC staff, were Kevin Carter on behalf of the permittee. He and the permittee were represented by Jeff McKean, who was present today. Counsel for permittee, also present was Prosecutor Wignall, prosecutor for the IATC. Notice was taken in the entire commission file, both electronic and hard copies, as well as electronic records of the Lake Circuit Court, and the state case there. There were other exhibits admitted and considered. That hearing was held pursuant to an agreement between the permittees, counsel, and prosecutor that the violations were admitted, but they wanted a hearing in regards to possible penalties in this case. Facts indicated or showed that in July of 2011, a fire took place at the permittee's place of business. It became non-operational. Permit was later placed into ESCO in 2012. Ms. Carter, Ms. Bernice Carter, who is the permittee in this case, passed away on December 25th, 2014. Her estate was opened in Lake Circuit Court on May 12th, 2015, and closed on November 27th, 2017. On May 30th, 2016, a letter was filed with the IATC requesting additional escrow time, and it was signed allegedly by Bernice Carter. On November 27th, 2017, Bernice Carter's estate was closed. A few months later, a letter dated June 18th, 2018 was submitted to the IATC by an attorney for a permittee who was not Mr. McKean in this instance. The letter requested additional escrow time and included exhibits showing a building permit that had been issued on May 23rd of 2018. Permit listed Bernice Carter as the owner of the property, that being the property that was the location of the permittee's business. On July 11, 2018, an application for renewal was filed listing Edward Carter as the manager with 0% interest in the permit, and Edward Carter signed the application as prepared. On August 6, 2018, a request for extension was filed and was signed by Bernice Carter. On March 9, 2019, an initial request for carryout was filed, signed by Bernice Carter, as both a client and applicant on March 8, 2019. Edward Carter passed away on September 8, 2020. On June 10, 2021, an application for renewal was filed, listing Bernice Carter as president with 100% ownership, and Edward Carter signed the affidavit of applicant. On May 28, 24, a renewal application was filed listing Bernice Carter as the sole owner with 100% ownership. The application was signed by Bernice Carter. On August 6, 2024, Mr. McKean, who was then counsel for permittee and remains so, he emailed the IATC with information acknowledging what had taken place, offering full disclosure and transparency. On September 30th, 2024, the Lake Circuit Court granted Shirley Carter's petition to approve the assignment and transfer of alcoholic beverage permit to Ms. Carter, which petition had been filed on September 24th, 24. Part of that order stated, quote, "The chair of the Indiana Alcohol and Tobacco Commission is hereby authorized to transfer the permit to Shirley A. Carter, subject to any additional requirements of the ATC and pursuant to Indiana Code 7.132410. On November 6, 2024, Ms. Jessica Allen, chairwoman for the ATC, provided written consent to continue operation of the business. At that point, the business had been closed for a period of 156 days. On March 6, 2025, the permittee, represented by Mr. McKean, signed a settlement agreement with Mr. Wignall, which I referenced earlier, requesting that the matter be set for hearing to determine penalties. I heard that matter on May 13th, 2025. There have been no operational or public safety issues with the business since they reopened pursuant to the consent to continue operation. However, I did find as a matter of law that permittee committed falsification of records for permit application, renewal, etc. on multiple occasions between 2018 and 2024 by submitting annual alcohol permit renewal forms with forged signatures of the deceased owner, Bernice Carter. Permittee also violated IC 7.13218 multiple times by failing to disclose any new ownership structure and or interested parties as required. IC 7.132320 provides the commission shall deny the application or revoke the permit of a person who includes on the list of interested parties required to be filed by 7.13218 a fictitious name or a person disqualified under this title for having an interest in an alcoholic beverage permit or omits from the list the name of the person whose name should be on it. The commission shall take the same action if the applicant or permittee fails to keep the list current as required by that section. I found that the language of IC 7.13218 and IC 7.1322320 is straightforward and mandatory. As a result, the commission's only remedy, I believe, is to order revocation of the permit RR 4506264. Mr. McKean has, on behalf of the permittee, filed extensive objections to the proposed findings of facts and conclusions of law. And if I may, essentially says that yes, these things happened, but that he brought forth the permittee, and they, not Ms. Carter, but the family, and they fully disclosed what had happened and admitted responsibility for that. However, in light of my findings that the law is pretty straightforward, I maintain my recommendation. However, I would note that I would not be opposed to a request for transfer being filed by Ms. Shirley Carter. Based on what I know no reason that she wouldn't be qualified to hold. Now that's just based on what I know, but that is my recommendation.
Second. Been moved and seconded. Is there any further discussion? I would just say, I agree. I think as to the current permit and Bernice Carter, the statutes are clear. If there was a request to transfer, have a new owner be vetted by local board, indicate how they intend to operate it, who's gonna be running it. I don't know if I'd be opposed to it, given what we know of Shirley Carter's involvement to this point and likely lack of involvement early on with the forged signatures.
There was no evidence in front of me, or that I'm aware of, that Ms. Shirley Carter was at all involved in any of that.
Oh.
Yeah.
I was, if I may, I was going to comment on that. My background suggests that the filing of fraudulent documents is kind of the end of the road for me. But if you're indicating that there was no indication that Shirley Carter was involved, I'll accept your recommendations.
Thank you.
It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next, hearing judge recommendation is RR 453815, Vibe Hookah Lounge and Catering Incorporated. This comes on for an order on a violation hearing.
Madam Chair and members of the committee, this was a violation that was filed against a tobacco license and the permittee up in Gary, Indiana. We held a pretrial hearing on September 25th of this year. And at that time, the permittee owner, Evan Simon, appeared, indicated he wanted to try to resolve matters with the prosecutor. They were given time to go communicate outside, came back in, and the agreement was to set this for a hearing. In the meantime, the permittee would try to resolve things, including the fact that the permit had been expired in February 14, 2024, almost a year and a half earlier. This matter came before hearing on October 14th. At that time, Mr. Simon did not appear. And we moved forward, heard evidence and testimony. And the testimony was that excise conducted an investigation there, found partially burned marijuana and ashes that tested positive for marijuana. Found several bottles open and unopened from Members Mark, which is now the permitted seller of alcohol to a location. There were open bottles of alcohol there, and there were some other violations that had been written. I heard testimony and evidence from the officer. Having heard the testimony and evidence and accepting the exhibits, which included pictures of the facility showing all of the things I just mentioned, I heard the testimony and evidence, found the violation true. Based upon that, the fact that the permit had been expired since February of 2024, and apparently no evidence or testimony that matters had been resolved to conclude further that they should continue to operate under the permit. I am recommending revocation of the permit for RR 453815 and resolution of excise number 24-003976.
Second.
It's been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. There is, I said there were two hearing judge recommendations. There is a third for today. That is BL 1133019 Jatinder Kumar. This matter comes on for proposed findings of fact and objections.
Madam Chair, member of the committee, this is a fairly interesting and complicated matter. The permittee Jatinder Kumar had filed for and received the issuance of a permit under DL 1132-33019 in Clay County. This is in a small town, and the intent is to open a store at a location that has been the subject of a prior permit application for a dealer's license. The local board heard testimony, including a remonstrator from the next door neighbor who has identified himself as having a church at that location next door to where the proposed permit will be placed. The question was the extent of and the validity of the allegations, the statements from the remonstrator that it was a church. There was extensive legal research on that. A hearing and trial was heard on this. The remonstrator was represented by counsel from the area, Darrell Felling Jr. Lots of exhibits submitted, lots of testimony proposed, not only by the permittee, Jatinder Kumar, and some others in favor through affidavit, but also from the remonstrator, Mr. Lyon, I think, who indicated that he has a church there. There's a sign out front that identifies the church. And the premises, the real estate that the remonstrator owns is a lot, and he owns to the west of that lot several other lots where he conducts businesses that include an auto repair store. But on the lot that is next door to the proposed Jatinder Kumar dealer's permit, there is a building in kind of setback with a road leading to it and a building. The picture evidence presented, Exhibit 2, showed the picture of the church, which I more likely would describe as a garage. And the picture that was presented had a car backed into that area. In other words, this is a garage, a building that has a garage door. The remonstrator testified that he has parishioners who attend, sometimes 7, but he said in many 12. To my knowledge, there are no utilities there, either electricity or heat. There is not a facility there for restroom. The remonstrator testified that if anybody needed anything, they could just go to his house next door. He did not know of a list of parishioners, which I thought was interesting. There was a second witness who later was notified as his wife that she has the list of approximately 7 to 11 people who belong to this church. There were documents submitted. The remonstrator presented his credentials as a certified minister. There was an IRS employer identification number, although he testified that he has no employees, that only he and his wife are involved. He had built the building in the summer of 23, which was shortly after a prior permit was not accepted by the community and was denied. It was just several months later that he got the employer's permit, had the sign built out front. So all of that, I came to the conclusion that this is not a legitimate church. While research indicated that there is no particular definition or indication of a church, that the items listed and the items testified to were overridden by the fact that there is a driveway that leads up to this building. There was a car parked in that building. There were no chairs in the building. There are no utilities in the building. There are no accoutrements that normally might be associated with a church. All of that then led me to the conclusion that the decision of the Clay County Local Board to allow the permit to be issued and continued and to begin the construction of the building should be affirmed. And my recommendation is to affirm the issuance of the permit under RR 11-33019 and to affirm the decision of the Clay County Local Board.
I would second that, understanding that the permit is DL 11-3301.
Sorry, thank you.
Been moved and seconded. Is there any further discussion?
I would just commend Judge Payne on his findings. They're very extensive and well researched, I think.
I would agree. I think it's also worth noting that in bad weather, the church moves from the garage into the house, shifting the church further away from where the package store will be located. And the building on the lot will be demolished. And so we don't have a distance from the new building to the church, whether it be in the one location or the other. So in addition to the well-researched findings on a church, I think the 200-foot rule is also too variable in this situation.
I would also insert the word purport in the full church.
Yes.
One more thing to Commissioner Jones' statement, my copy of the proposed findings in the final order recommendation lists RR 11. If we can show that amended to DL 11.
We will show that amendment.
Okay.
All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item on the agenda, consideration of applications. There are 309 renewal applications.
Madam Chair and fellow members of the commission, I incorporate by reference the list of 309 applications for renewal. Those have been recommended by local boards and reviewed by staff with authority of the commission. I hereby move for approval of the same pending any needed escrow hearings. Further move for inclusion of this list as part of the minutes of today's meeting.
Second.
It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item on the agenda, 22 new and transfer applications.
I incorporate by reference that list of 22 permit applications for a new permit or applications for changes in ownership or location or both of existing permits. Those have been recommended by local boards and reviewed by a commissioner. I hereby move for approval of the same, pending a final floor plan approval by the state excise police and an escrow hearing if needed. Further move for inclusion of this list as part of the minutes of today's meeting.
Second.
It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item, 48 catering applications.
I incorporate by reference this list of 48 permit applications for catering, hereby move for approval of the same and for inclusion of this list as part of the minutes of today's meeting.
Second.
It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item on the agenda, one direct wine shipper application.
I incorporate by reference this extensive list of one new and renewal direct wine shipper permits, hereby move for approval of the same and inclusion of this list as part of today's minutes.
Second.
It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item, waivers and fees for letters of extension.
Madam Chair, members of the committee, we've received or looked at documents regarding the waivers fees of letter of extension. I move acceptance of those.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Items for discussion. The first one is RR 4536364 Playos Nightclub LLC. This is a renewal with local board voting 3-1 to approve for 1 year and an extension request.
Yes, this has been on our agenda for quite some time. It is actually started back in August with an extension and then the consideration of the renewal from the local board, which is before us now. They did have violations and that's why it had to go for a local board hearing. We had questions that were raised right before the last local board hearing regarding new information that came up on possible other owner or manager. We found that at the Secretary of State's office, there was only one person listed with them and he was listed as a CEO. However, that person was not anywhere on our application as an owner, manager, bartender, server was not related to the business at all. I will note that, this business has had problems in the past disclosing, their employees did not have permits and training. We had several rounds of paperwork for them to disclose that to us. All throughout that, they did not disclose that there was a manager. And nowhere did they disclose that there was a manager. Didn't submit his permit, didn't submit his training, just last week submitted, after we found through the Secretary of State's document that he was related to this business as CEO. We contacted and asked for further information about who this gentleman is, and a manager's questionnaire was filed with us just last week on this person. It's hard to believe that we've gone through looking at this permit since August and requesting documents on employees, all employees, their permits and their training, and the manager did not come to light that they should share this information with us, that he works there, that he's the manager, and file documents that are related to him. I will also note that I've gone back and looked at some social media information related to this business. And this gentleman in question lists on social media in at least 2 places that he is the owner of this permit. I don't know why someone is promoting themselves as the owner when he's not the owner with us. That's very confusing. Also, I will note that the type of music that this event plays probably caused some problems for them in the past. There was a shooting, there were deaths that did happen in this bar when a promoted entertainer came in. So I am concerned about what kind of music they would be playing in the future. And I think they have stated that they would be selective somehow, but on their corrective action plan, I don't see anything that tells us how they would be selective about what music would be played there and what kind of clientele they're trying to attract by the music they're playing. Because of these items that have come to light, I am going to move that we remand this permit back to Lake County. And I would like the owner and the new manager to at least appear and have questions about why this manager was never disclosed in the past, how long he's actually been managing related to the bar, why he's listed at the Secretary of State's office as the CEO. Normally a CEO has ownership in the business. And I would like some information too about the type of music, the type of promoters that are going to be used. The new manager, I think on social media, it looks like he has a company that does promotions. And I would like to know what relationship that business may have to this permittee. So remand for the owner and the manager to address those questions and any others that come up. And that is my motion for R 4536364 Plios Nightclub LLC.
Second.
It's been moved and seconded. Is there any further discussion?
I would just like to comment, and we heard this just a few weeks ago. And you may recall that I talked about the safety plan that they originally submitted that had lots of shoulds and woulds and maybes to it. They have submitted a new corrective action plan that I think is much more appropriate, more directly addresses those issues. I would suggest though that we spent a lot of time on this. I have lots of paperwork on this that has been studied, and I'm an old guy. I still listen to the Kingston Trio. Don't laugh.
Loves Kingdom Trail.
I do too. So I don't know, who are they? I don't know about music, but I think what I take from what Mr. Magnan talked about was the culture and appearance. And what you tolerate, what you accept, what you display will have a great deal to do with what happens. So the corrective action plan, I think, addresses the specifics of the rules and regulations and the expectations of this commission. But I would suggest that perhaps this permittee ought to look at what the culture and practice and what environment they allow and support and tolerate. Whether the music is part, I don't think the Kingston Trio are that controversial. They may not be well known, but music and other things does address the issues. And again, I say this all recognizing that their first safety plan in my mind, was totally inadequate, which means they really don't understand, at least at the time, did not understand the importance of the culture and what they were doing in the building. I'm going to support the recommendation for remand.
Did the motion address the extension request?
No.
No on the extension, no on the renewal, remand to, the local board for the items identified.
All right, I will show the motion amended to include a motion to deny the extension request.
Second.
Okay, it's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item on the agenda, RR 5538520, the Farmhouse Brew renewal with the local board voting 3-0 to deny.
Yes, this comes to us from Monrovia. There was a local board hearing in July that was continued to August. The August meeting was held. The owner of the permit appeared a bit hostile and was really kind of a hindrance to the hearing and to excise on getting information about how this alcohol permit is being used. Questions that were asked for, is the Farmhouse Brew, are they selling alcohol at this alcohol establishment? And also asking when they last purchased alcohol from a distributor, employee permits and training, and other such information that should be easily to produce and come forward with. Because there was some hostility and hindrance, it was continued to September. September, they asked for another continuance. It was scheduled for October, and there was a no-show in October. I'll just note that they did finally produce some paperwork from a distributor that shows that their last alcohol sales were 2019. We're not sure how they're using this alcohol permit, possibly off-site events. I don't know that they're approved for that. Anyway, I think the denial was a good idea, but it's more than just a no-show. I have questions about how this permit is actually being used. So they're coming back to us for a reconsideration. I've got a lot of questions for them, but I move that we uphold the denial for RR 5538520, the Farmhouse Brew.
Second.
Been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item is RR 2000853 Barnes and Barnes Incorporated. This is a renewal with the local board voting 3-1 to approve for a 1-year renewal.
Yes, this is in Elkhart. The local board heard this on October the 16th as it was a renewal after violation. They have had some 6 violations over the past 12 years, 4 in the past 10 years for such things as character of business, 2 alcohol compliance checks that were failed, employee permits, no minimum food, those types of events, not good when you're failing alcohol compliance checks. And one was from the owner's son. He just didn't check ID. One thing that we did not get from them is a corrective action plan. They currently have an extension until December the 2nd. I'm going to move that we continue this permit to November the 18th. Ask legal to send them a note telling them they need to submit a corrective action plan, outlining their violation, having them check their violations and come up with a corrective action plan on how they're making sure that those don't happen again, especially failing alcohol compliance checks, which are sales to minors. And I'm also going to ask excise to make some surprise visits to this business. It appears that maybe they do not have the correct permit type. They seem to be operating more as a liquor store than a restaurant. I think they are selling a lot of, it sounds like they're selling a lot of packaged liquor to go. And maybe we need to look into that further down the road and see if they're actually in the right permit. But that's my motion for RR 20000853 Barnes and Barnes Inc. Continue to November the 18th. Ask excise or ex legal to send a letter asking for the corrective action plan.
Second.
It's been moved and seconded. All those in favor, or is there any further discussion? Not seeing any. All those in favor indicate by saying aye. Aye. Opposed, say no. Motion carries. Next 2 permits I'll call together. They are RR 8401565 Wabash Valley Hospitality Incorporated and RR 8403694 Wabash Valley Hospitality Incorporated. Both of these are renewals with local board voting 3-0 to deny.
Yes, this comes to us from Vigo County and Terre Haute. Both of these permits are in escrow. The owner has 3 permits. He's only operating 1. He only has 1 open right now. These, because of violations in both of these businesses, he did put the permits into escrow and is concentrating on selling them. The second one, he actually has a contract to sell it. The owners, the people who are buying it need to sell a house before they can come up with the money to purchase it. So there is a signed contract, but I don't know how quickly that's actually going to be transferred. The second one, he has not started advertising for sale yet. Our excise officer did advise him that later down the road, when he's ready to transfer, we may look at that later, but for now, the local board did recommend denial on both of these permits. And I move that we uphold the denial for both permits, RR 8501565 Wabash Valley Hospitality Inc. and RR 8403694 Wabash Valley Hospitality.
Second.
It's been moved and seconded. Is there any further discussion?
I would like to comment if you don't mind, or even if you do. Yeah, I listened to these or watched both of these, and I certainly support the recommendation. I was struck though by one question and one answer that I think deserves some public comment. There apparently have been problems at one or both of these locations, and they were discussed, even though they are currently in escrow and not open. But a question was asked by one of the board members of what kind of security they had there, what kind of individuals they had there. And The answer was that he had just hired a local truck driver to be the security. The question was, what background, what training, what experience does the truck driver have? And then there was stunned silence, like, well, do you need that kind of stuff? Or should I think about that? And I was just struck by that in this particular instance, but also with other things that we've seen over the years, 3 years that I've been involved here. There doesn't seem to be enough attention, enough respect, enough understanding the importance of having the right security at a restaurant or bar, perhaps bar more than anything else, who is trained, qualified, understands, is prepared to serve in the capacity of a qualified and appropriate security. So I say that publicly now, encouraging everyone to reevaluate their security, whether that is law enforcement or a private business or just an individual, to make sure that, at least in this case, the total indication was that there was a total lack of security and understanding along with that. It's not just that they have to be big and strong and mean and verbally sound. They have to have all sorts of tact, diplomacy, perception, identification rights. So I just mentioned that, and this seems to be coming up frequently, and in this case, it just struck me as a glaring absence of understanding of what needs to be done. So I comments.
I would just note, as Commissioner McGinn indicated, there was discussion about the transfer. The local board felt like they shouldn't renew and allow the transfer because then what if they reopened? What if they continued operating? So I would just note that if it's timely appealed and a request is made under Rule 36 to transfer, we may still consider that transfer, but I don't think that the denial is arbitrary and capricious, and I'm going to vote to uphold it. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next permit for discussion is RR 4936555, Mimi's Event Lounge LLC. This is a renewal for the purpose of transfer. I think they requested transfer from us with a renewal. To get that transfer accomplished, they submitted a subsequent renewal. We requested an updated power of attorney to make some of the signatures valid and a tax hold clearance. We finally received that this week. And so I think now the transfer is ready to go. I would move that we renew the permit in order that the transfer be completed within the next 30 days. I think it is ready to go now, but 30 days to get it accomplished in case there is any missing information. So that would be, give them until December 2nd of 2025.
Second.
Been moved and seconded. Is there any further discussion?
I didn't hear it as part of your motion, but I want to make sure that that's what you meant. The renewal is only for purposes of training, right?
Correct. So the extent that my motion needs to be amended, I will show that as part of my amended motion.
To the extent that needs to be seconded, I will second that.
All right, so it's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries.
I had too much sugar this morning, I apologize.
You already said enough.
Next permit for discussion is RR 8441351, the Alamo Steakhouse LLC. This is a request to schedule a local board hearing.
Yes, this comes to us from Terre Haute. This is a three-way weekend permit. It expired October 28th. It did receive an extension until January 27th of 26. This was wrongly automatically renewed. It should have been, sent to the local board for a hearing because it was just a 1-year renewal last time. So I'm gonna, make a motion that we, if it's not already done, that we reverse the prior auto renewal, set that aside and, ask for this to be scheduled for a local board hearing for RR 8441 the Alamo Steakhouse LLC.
Second.
Been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item for discussion is RR 5337838. Yatagarasu Ramen Incorporated. This comes on for an extension request continued from our October 7th meeting.
Yes, this comes to us from Monroe County. We were, it had been administratively dissolved. There was tax protest. This have both been taken care of. I move that we grant an extension for 90 days for RR 5337838 Yatagarasu Ramen Inc.
Second.
Been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item for discussion is MM 08299942 DTA Farms LLC. This matter comes on for an extension request.
Yes, this is a farm winery from Carroll County. We were waiting for some certificate of insurance, which has been provided. They have an extension which runs from August the 18th of 25 to November 16th of 25. Unfortunately, they had an owner who passed away. He was a 60% owner. I understand they're having some challenges with an attorney who is contesting the will, an administrator of trustee who resigned. I'm going to move that we grant a 90-day extension, a second 90-day extension for MM 08299942 DTA Farms LLC. Hope they can get that moving along.
Second.
Been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item for discussion is RR 4940045 Miami's Garden LLC. This matter comes on for an extension request.
Yes, this is a 209 permit here in Marion County. Marion County Local Board did previously hear this for renewal on July the 7th. They recommended a denial. We upheld the denial on July the 15th. They did find timely appeal of that denial. There was a pre-hearing conference held on October 28th, and there is now an appeal hearing set for January 22nd. They have hired counsel. They have submitted corrective action plan. I felt like the corrective action plan did address their 5 violations that they had in 24. Never like to see someone who's had 5 violations in 24. But I'm reluctant, but I am going to recommend that we grant a 90-day extension since they have hired counsel, they have had gone through pre-hearing, and they have their appeal hearing scheduled, and that is for RR 4940045 Miami's Garden LLC.
Second.
It's been moved and seconded. Is there any further discussion?
I'm scheduled to hear this, so I'm going to abstain from voting.
I'll be a no vote. I was a no vote on the last extension, and so consistent with my concerns on the last one, I will be a no vote today. It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. No. Motion carries 2-1 with 1 abstention. Next item for discussion is RR 4939978 Fusion Incorporated. This matter comes on for an extension request.
This one is also here in Marion County. Marion County Local Board recommended denial on October the 7th. The ATC upheld that denial on October 21st. There was very timely appeal filed on October 29th, just last week. They have filed a corrective action plan. I thought it was very good. And I'm going to move that we grant a 90-day extension for RR 4939978 Fusion Inc.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. No. Motion carries 3-1. Next item for discussion is BL 4932087 Royal Petroleum Extension Request.
Yes, this comes from Marion County. They have had 2 extensions. The first one May 2nd of 25 to August the 2nd. Second one from August the 5th to November 3rd. They do not have any violations. They are working on ownership updates. I move that we grant a third 90-day extension for DL 4932087 Royal Petroleum Inc.
Second.
It's been moved and seconded. Is there any further discussion?
Consistent with my traditional opinion on these, I don't think it should take that long to determine who owns this. For the third extension, I'm going to vote no.
Right, all those in favor indicate by saying aye.
Aye.
Opposed, say no.
No.
Motion carries. Next item for discussion is RR 4938051 OHSR Enterprise LLC. This matter comes on for an extension request.
Yes, this is also from here in Marion County. It was there was a local board recommended denial on June the 2nd of this year. We upheld that denial on June the 17th. There was a timely appeal hearing filed. There have been 2 pre-hearings held, one September the 11th and the other on October 28th. And now there is an appeal hearing that has been scheduled for December the 8th. They have submitted a corrective action plan. They have an attorney. I felt like the corrective action plan did address the violations that they have had. There are 2 violations, and I'm going to move that we grant a 90-day extension for RR 4938051 OHSR Enterprise LLC.
Second.
Been moved and seconded. Any further discussion?
I again am hearing this matter, so I will abstain from voting on this motion.
I will just note at the last extension we considered, one of our requests was that they get this scheduled for a substantive hearing on the appeal. I think these appeals are still taking too long. The denial was either appropriate or it wasn't, but let's get the hearing scheduled and make those determinations. So we discussed that at the last hearing. They have scheduled that substantive hearing, so I will be voting yes here. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. I will show that that passes 3-0 with 1 abstention. There's 1 extension to add to the agenda today. That's RC 9200454 Columbia City Lodge number 1417. This matter comes on for a second extension request.
Consent.
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 We'll show that added to the agenda by consent. Thank you. And I will open that for discussion.
Yes, this business previously had a paperwork problem. They are all cleared. They had a first extension from July the 26th of 25 to October 24th of 25. They did expire July 26th of this year. They do not have any violations. They are now scheduled for the local board on November the 18th. I move that we grant a second 90-day extension for RC 9200454 Columbia City Lodge 1417.
Second.
It's been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item, inactive files. We have 19 permits to be made inactive from the October 21st, 2025 meeting.
I move that we make the 19 permit that were listed for us on the October 21st, 25 agenda I move that we make those 19 permits inactive.
Second.
It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. I will just note there are then 19 permits to be made inactive on the November 18th, 2025 meeting. Notice has previously been sent. If you haven't responded to those prior notices and it's your permit or your client's permit, get those renewed. No escrow hearings in December. Not seeing any other items on the agenda, I would entertain a motion to adjourn.
So move.
So seconded.
Been moved and seconded. All those in favor indicate by saying aye.
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 Opposed, say no. Motion carries. We are adjourned.
I will take sweet tea off of the menu for the morning from now on.
I think, yeah,